resolution and arbitration, and what could possibly be done? Yeah.
See, I have been handling arbitration for last 20 years, and my experience has been we all talk about everything, and we don't want to take any positive steps. The problems that I see, the agreements are drafted in mundane manner, same formats as my friend is also talking about, Mr. Shankar, like arbitration clause. I have never seen in last 20 years any contract where the PSU has made any effort to change the arbitration clause in the manner in which it is written. All the arbitration clause says first engineer, then DRB, then arbitration. And then nobody pays any heed. Of course, because the provision is there, they will go to the DRB. Now, they spend a lot of time, energy, expenses, costs, etc. And there are recommendations of the DRB, but nobody is ready to accept them. Of course, I am not saying, like in some cases, contractors are also not willing. Of course, department definitely is not, because they feel that there will be some kind of a problem of the account general, etc. So they don't want to take that burden on their head. So what I have seen over the period, it is the problem is primarily of the mindset that we work with, and we don't want to change actually. Supposing, take for example, if we want to really reduce the disputes, why can't we accept the decision of the DRB? Because, and there is a recent judgment where the Supreme Court has extracted, setting aside the award, the decision of the DRB in extenso. And those set of people are only acting as a DRB, who are also acting as arbitrator in another case. So there is no problem of any kind of, whether they lack experience or they lack knowledge. They are absolutely fantastic people. Those who are doing arbitration, those set of people are only doing DRB. Now the other thing comes, as we have said, it has been pointed out, that challenging the award. Now this is another problem, and more so with the government department, because they want to challenge in a routine manner. But things have changed over the period. Like I can say definitely for Delhi High Court, it is not that easy that you go to the court and your petition under 34 gets admitted. You have to convince the judge. Other places definitely, because they are not even conversant with the idea of arbitration. If you go to remote places of Punjab and Haryana, if there is a 34 petition, they would want you to lead evidence. So they have no idea whatsoever. And in one of my matter, I showed a judgment of the Supreme Court where it is said that at 34 stage, there is no evidence required. But he says, forget about this judgment. You please tell me whether you want to lead evidence or not. So this aspect, of course, somebody who can really look, and they're kind of like, I don't know how this metro people have done, because I have no experience, but it is said that, you know, they have been taking decisions right at this stage, and the disputes are curtailed. So those things, I think somebody has to really, even the contractor community, like when they sign the contract, in many cases, sir has also said, they close their eyes and they sign the contract which is not viable, which they know on day one that it is not viable. They can't make any money out of it, but they have their own compulsion. And then it is thought that, okay, let us start doing the work, let us see what kind of claim can we make. And you know, the problem is in the mindset. We don't want to take hard decisions. That is the problem. Now, when we come to arbitration amendments, of course, our legislature has been trying, I think in the last 20 years, they have brought 2-3 time amendments. Now, let us talk about the recent amendment. They have brought in this council, which of course, I feel it was required in some way, because it is a positive step. Otherwise, there is no control over this arbitration business at all. Except to the extent, our court also see whether the award has to be set aside or accepted on the parameter which are laid down in section 34. Beyond that, they don't do anything. They don't go to punish any arbitrator. They don't pass any remark against the arbitrator. They don't say that such and such person should not be put as an arbitrator because his determination is per se wrong. So the first, I think this is a positive step, because they will give some kind of accreditation, and they are going to lay down some parameter who can be the arbitrator, and they have added some qualification. By adding qualification, they have not done any great job. They have just added what has been practiced till now. We have seen in arbitration, only senior people are becoming arbitrator. Many technical people who are engineers, they have degree in law also. So by and large, they have only brought it as a matter of statutory recognition. What they could have also done, for an example which sir has taken, Like in our country, you know, what is happening is the arbitrator are people who have crossed the age of 75. Now, you see, the point is, it is a very, very serious business. After 75, you are not able to register. I have seen arbitrators sleeping in the arbitration. So why can't our law says, when we say talk about retirement age everywhere, like recently also in this, the council, it says the maximum year is 70 years for a chairman and a member who is not an ex-officio member. So why can't we bring in similar provision where, you know, the arbitrator, if he has crossed a particular age, I'm not saying 70 for all, maybe it is 75 or something, that if he has crossed that age, he should not be appointed as an arbitrator. So those kind of things we have to see. Similarly, section 34, there was a provision that petition should be disposed of within 1 year. But then there is a judgment of our own Supreme Court which says, because this is not mandatory. And so far as legal aspect is concerned, he is right. Because there is no consequence. Law does not say as to what happens in case the petition is not disposed of. Unless that is done, it does not become mandatory. So instead of maybe not 1 year, it can be 2 years or some reasonable period with a consequence as to what will happen. Maybe that the award can be accepted, has to be accepted or something like that.
Sure. Thank you, Mr. Goyal.